We are the first generation to feel the sting of climate change, and we are the last that can do something about it. Our towns are burning, our fields are flooding, Miami is inundated.
Your government was dumping radioactive waste from nuclear weapons production and its own reactors until the year 2004, when we put those pictures on air and in our campaign literature for Initiative 297.
And we have to understand, this is a climate crisis, an emergency.
The government thinks it's okay for radioactive waste, even though it seeps right out of those trenches. And that stuff is all moving through the soil to the Columbia River. What they're not telling the public is that they also deliberately dumped out of the high-level nuclear waste tanks in the 1950s and 1960s billions of gallons of liquids into the soil. And it is very, very toxic. It is radioactive. It includes uranium, that with half-lives of hundreds of thousands of years, and plutonium, and technetium-90, and strontium-90, and technetium-99, and all sorts of chemicals as well. And it's a witch's brew of deadly wastes, and it's all moving towards our lifeblood, the Columbia River.
But the most important thing on this, and the biggest decision for the American public, is who's going to make this the first priority. And I am the candidate and the only one who's saying this has to be the top priority of the United States, the organizing principle to mobilize the United States so that we can do what we've always done.
Washington state politicians have also known about these as very serious problems all along. Yet within the Washington State Constitution, Article 1, Section 2, Federal Law Rules, 18 U.S.C. Section 2 Principles, anyone assisting in the commission of these crimes is punishable as a principal. I therefore have just filed a federal lawsuit and criminal complaint against Governor J. Robert Inslee, bar number 6824, and the Department of Licensing for treason against we the people for lying to us all about the legal definition of motor vehicle and robbing us for decades. Extortion.
The road to infinity is on my back. Like some people's minds get mixed in a haystack.
Again, the Washington State Constitution, Article 1, Section 2, Federal Law Rules, and has always mandated the legal definition of motor vehicle as commercial. 18 United States Code, Section 31, Subtitles 6 and 10. Lawmakers' legal definition of motor vehicle, which stated the same commercial definition as Federal 18 United States Code, Section 31, Subtitles 6 and 10. Motor vehicle means commercial, for business, and for making a profit. State of Washington. Motor vehicle shall include all vehicles defined. Motor vehicle or machines propelled by any power other than muscular and used upon the public highways for the transportation of persons, freight, produce, or any commodity. B. Commercial, relating to or connected with trade or traffic or commerce in general. 3.1, Article 1, Section 2, Washington State Constitution, Federal Law Rules. U.S. Constitution, Article 6, Clause 2. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. 3.2. Yet the state of Washington, under an act of treason, 18 United States Code 2381, in 1961 rewrote the federal definition of motor vehicle, changed or withdrew commercial from the federal law in violation of Washington State Constitution, Article 1, Section 2, and many mandates of the Supreme Federal Constitution under a conspiracy against rights, deprivation of rights under color of law through extortion, and treason. The Washington State Legislature schemed and committed the federal violations listed under the above 2.1, having executed the unauthorized change of federal law, in doing so, changing the state's legal definition of motor vehicle by withdrawing the definition of commercial found under motor vehicle, and the above numbers within this suit, 1.3 A, B, 1.4, 1.5 A, B, C, D, E, and violations under number 2.1. 3.1. The legislative state's scheme is to commit extortion through frauds and swindles against we the people, the United States of America. Here's how they did it. A. Fooling we the people into believing they're subject under the commercial legal definition of motor vehicle, 1.3 A, B, 1.4, 1.5 A, B, C, D, E, and violations under number 2.1 in the rewrite of the 1961 Full Motor Vehicle Code by changing supreme federal law by withdrawing the legal definition of commercial. What they came up with was Revised Code of Washington, RCW 4604320, motor vehicle. Motor vehicle shall mean
Now, what I'm going to talk about today for the most part are your rights, especially when it comes to things like public service and servant encounters involving traffic stops, sidewalk stops, public building stops, so on and so forth. It would surprise you to a great degree just how much the American people are no longer in touch with what their basic, common, unalienable rights actually are. We've been indoctrinated into surrendering them to the state and to those that we judge to be in authority over us for far too long. It's probably one of the biggest reasons for government-controlled schools is simply because this indoctrination process has to be done slowly, because what they're telling us about what we have as far as rights are concerned and how they actually treat us in regard to those rights are very much in contrast and in contradiction to each other. But by doing it slowly over time the way they're doing it, most people have gotten to the point where they don't even notice any longer that they have been deprived of those rights until it's far too late. This is the transportation script that I wrote and am currently recommending for use whenever you're engaged in any type of public interaction, most appropriately a transportation stop, but it can be used in any situation where you're having to deal with any type of public servant who is attempting to exert some sort of authority over you or your property or something of that nature. So that being said, there's a couple of general rules when it comes to dealing with public officials. One of the things I've got here on the transportation script is it's best for you to memorize as much of the actual questions portion as possible. The instruction portion, don't have to worry about memorizing. You just need to know the basic premise of why the instructions are what they are, so that you can apply them properly to the questions and the context in which you're having to use them. That being said, one of the major rules I stress vehemently to the people in my class is you're no longer in the world of rights and safety. You're in a world of government intolerance of the very people that empower and create it. The government wants you to be its subject, not the other way around. So, never leave home ever again without some form of recording device with you. Doesn't matter if it's your cell phone, doesn't matter if it's a voice recorder, doesn't matter if it's multiple of either. Don't leave home without something that records. Anytime you find yourself in a situation where you are about to have to deal with a public servant, I don't care if it's someone you've known for years, but you are going to see them in their official capacity as whatever they are, a court clerk, court of record clerk, the county clerk, whatever, you record that encounter. You never know what your public servants are going to attempt to do at any given time anymore. Police officers are being trained to treat us as the enemy. They are first and foremost the ones you have to watch out for. Never talk with a peace officer, police officer, or any other type of officer if you're not recording the encounter. All right, now in the transportation script, you'll notice the yellow highlighted area at the top, the do's and don'ts. These are very important things you need to know. You don't have to memorize these, you just have to know why they exist and what they are for. The first one is, do remember that an officer is required to read you your rights before questioning or searching you if they have placed you in a custodial arrest. Now, one of the things that most people in Texas do not know is that every time you are stopped for an alleged transportation stop, you are already in a custodial arrest. There are many sections of Texas law that make that clear, but the one that will make it the most pointed will be Chapter 543 of the Transportation Code, where it talks specifically about the arresting officer may release the person arrested from custody and so on and so forth. You also have a Texas court case that says very clearly that that arrest that occurs in 543 is a custodial arrest. So they will always tell you, however, that you're not under arrest. They will tell you that you're in a custodial detention. This is a lie. The reason they're doing this is to get you to start talking freely. Because under arrest, you're liable to watch what you say. Under arrest, they have to read you your rights, which is what this is dealing with. If they don't tell you that and you just talk freely, then anything you say can and will be used against you, and you can't get it suppressed later because the court will view it as a voluntary statement. So you need to know immediately that the moment the lights come on in Texas relating to any form of traffic stop, you are already in a custodial arrest, and you need to act accordingly. That being said, when you look at this and you read 543.001 through 009 of the Texas Transportation Code, you will see that that's the case. You'll also see that the reading of your rights is a mandatory requirement that works in your favor unless you're dumb enough to continue to talk after you've been so informed of this. And you can see that under Article 38.22 of the Texas Code of Criminal Procedure. Be aware, however, that the cops almost never read you your rights. Never. Not when they arrest you, not when they search your car, not when they do any of that. And they're required to do it. So, these are the things you need to be aware of. That means anything you say that can be incriminating, like using the 7 deadly sins, or agreeing with the officer that you were driving, or that this is a vehicle, anything you say or do in that regard is a nail in your coffin at trial. Because you're basically admitting that what he's accusing you of, the regulable activity of transportation, is actually applicable to what you're doing to your car and to your actions and to you personally, when in fact it isn't. But because you're so used to these terms that they're using, you simply agree with them. That's your first mistake. So one of my major rules is there's 3 parts to this. You shut up, you keep shutting up, and when you've done that, you shut up some more. Now, we'll get to that in the do's and don'ts in the next one here. Right now, let's finish this up. Oh, keep it back up, please. Okay. Since they never read you your rights and you are in a custodial arrest and the officer is lying to you about the custodial arrest, you need to make sure you know that, okay? You are always in a full-blown custodial arrest. Okay, now pop that other one up. All right. Don't ever answer an officer's questions. There's no requirement for you to answer their questions. I don't care what they tell you. There's no requirement for you to give them anything that they want. Yes, Texas law says you have to give them a license, you have to give them registration, you have to give them proof of insurance. Problem, that's a due process violation. The law is attempting to make it mandatory that you waive a protected right in order to exercise some alleged privilege or exercise an actual right of another type. And it can't do that. No law can do that. That law is invalid on its face the moment it attempts to do that. So you have the right to remain silent, use it. However, remaining silent does not mean become a deaf mute. You still need to talk and you still need to respond in certain ways. It's just not going to be in a way that implicates you or provides them with evidence or information they can use against you. That's what be silent means. Not stop everything. It simply means don't be saying and doing anything that helps them and hurts you. That is the reason why I have a major 3-part rule about everything here, and that is everything that comes out of your mouth has to be directed to one of 3 specific purposes: invoking a right, demanding a right, or protecting a right. If anything you're saying or doing isn't intended to do one of those 3 things, then you're doing the wrong thing. That being said, it simply means, again, to not be a deaf mute, that you are not to provide any information or documents in response to the officer's demands or questions. That means you don't give him a license, you don't give him registration, you don't give him proof of insurance or anything else. All of these will be considered at trial to be a waiver of your protected right to remain silent. It will be considered a waiver of the requirement that they Mirandize you before they seize evidence and statements that they can use against you. And believe me, folks, all of this information can be used against you. It can also be used to further incriminate you. An example being, let's say your birthday was yesterday, and you have a license that you give the officer that says your birthday was yesterday. Can the officer under Texas law charge you for driving without a proper license? Absolutely. It expired yesterday. on your birthday. So unbeknownst to you, you provided him with something that he can actually charge you further with. And he's got the actual evidence because you gave it to him. If he demands that, or the prosecutor demands you produce your license at trial so he can show that it was expired on the date the citation was issued, what are you going to do? You're going to have to produce it. You can't have it suppressed because you voluntarily gave it to the officer at the time. You waived your right to remain silent by giving it to him. Same thing goes if you have the wrong or an expired insurance card. Same thing applies with registration, any of it. They can't compel you to waive your right to remain silent and not to self-incriminate in order to meet their requirement of tell me that you have what I want. Because what they want is for you to allow them to get you in that vice of pay us money or we'll come after you for more money. That's what they're after. So, again, the three fundamentals. Any information or documents in response to the officer's demands or questions is going to hurt you. Invoke your fundamentally protected right to remain silent and to assistance of counsel, and then simply refuse to waive those rights. How do we do that? Well, you waive it because you complied with the officer's demands. The moment you comply, it's waived. You're done. It's over. You cannot get that back. You cannot ask the information be suppressed because the courts will say you gave it up voluntarily. The foremost thing to remember in these situations is to not engage the officers in idle conversation, dialogue, or chit-chat. Why? Because the more comfortable you are and the more talkative you become, the more likely you are to say or do something that's going to hurt you somewhere down the line, or that will give this officer more information he needs to conduct what he's going to refer to as articulable probable cause or a heightened reasonable suspicion to say that you were doing something more illegal or that would give him an opportunity to go fishing down a different path. So don't just talk. Again, if you're doing that, you're doing it wrong. Now, this is known as my self-imposed rule of invoke, demand, and protect. Once you've invoked these rights, you never waive or abandon them by ignoring the procedures I'm giving you here. Any question the officer asks, like where are you coming from, where are you going, who are you meeting, they have nothing to do with the stop. Stop answering those questions. It's none of his business. He has no right or authority to know that. The only way he's going to get those answers is because you give them to him. And he has no business knowing. Stop giving your whole life up to these people just because they tell you they want it. They are used to simply getting these are used to get additional information that may allow the officer to continue his witch hunt and escalate the severity of the charges he might make against you. Also, never answer questions like, do you know why I pulled you over? Or are you aware that you... Stop helping this guy screw you over. That's what he's doing. When he asks those types of questions and you answer, what are you doing? You're giving him evidence. Well, yeah, I guess you caught me speeding back there or running that stop sign or going through that red light. Thank you for the confession that he has on his audio-video recording and will use against you in a court of law. Stop answering questions. Just don't. Next slide, please. You do need to remember to do the following immediately when you realize you're getting pulled over. First and foremost, roll up all of your windows and lock all of your doors. Okay, why? Because these guys are getting more aggressive every day about jumping in your car without any probable cause, coming in from the passenger side, your side, and just pulling you out of the car for no good reason.